This is the UCC connection, how to free yourself from legal tyranny. Happy is the man that findeth wisdom, and the man that getteth understanding. Proverbs 3:13. Governments are instituted amongst men, deriving their just powers from the consent of the governed. This article has really filled in the voids that kept me from fully understanding things. I have found it to be one of the best discussions on the subject of freedom and how our own government has managed to take away freedom away from us, all while giving us lip service to the Constitution. The title of this article is The UCC Connection. The noteworthy author is Howard Freeman. It is dated September 22nd, 1991. The UCC Connection, How to Free Yourself from Legal Tyranny by Howard Freeman. This is a slightly condensed, casually phrased transcript of tapes of a seminar given by Howard Freeman in 1990. It was prepared to make available Mr. Freeman's knowledge and experience in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who want to develop a deeper understanding of this information without having to listen to 3 and 4 hours of recorded material. The frustration many Americans feel about our judicial system can be overwhelming and often frightening, and like most, fear it is based on the lack of understanding or knowledge. Those of us who have chosen a path out of bondage and into liberty are faced eventually with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts. We have been taught that we must get a good lawyer, but that is becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that the lawyers quickly take our money and then tell us that as the ship is sinking, I can't help you with that. I'm an officer of the court. Ultimately, the only way for us to ever have a snowball's chance into understanding the rules of the game and to come to an understanding of the true nature of the law, the lawyers have established and secured a virtual monopoly over this area of human knowledge by implying that the subject is just too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage. While it may at times seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really as smart as they would have us believe? Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers know procedure, not law. Then answered one of the lawyers, and said unto him, Master, thus saying thou reproachest us also? And he said, Woe unto you also, ye lawyers, for ye lade men with burdens grievous to be borne, and ye yourself touch not the burdens with one of your fingers. Woe unto you lawyers, for ye have taken away the key of knowledge, ye entered not in yourself, and them that were entering in you hindered. That's a Luke 11:45-52. Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize the lawyers learn about procedure, not about the law. Mr. Freeman admits that he is not a lawyer, and as such, he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote it in a language simple enough that the people could understand, specifically so that it would not have to be interpreted. So again, we find, as in many other areas of life, the buck stops here. It is we who must take the responsibilities for finding and putting to good use the truth. It is we who must claim and defend our God-given rights and our freedoms from those who would take them from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skills, and talents of others. To these ends, Mr. Freeman offers simple, hopeful explanation of the plight and a peaceful method of dealing with it. Please take note that this lecture represents one chapter in the book of his understanding, which he is always refining, expanding, improving. It is, as all bits of wisdom are, a point of departure from which to begin our own journey into understanding, so that we all might be able to pass on to others great knowledge and hope, and to God the gift of lives lived in peace, freedom, and praise. I send you forth as sheep in the midst of wolves. Be ye therefore wise as serpents and harmless as a dove. Matthew 10:16. Introduction. When I beat the IRS, I used Supreme Court SC decisions. If I had tried to use these in court, I would have been convicted. I was involved with a patriot group, and I studied Supreme Court cases. I concluded that the Supreme Court had declared that I was not a person required to file an income tax, that tax was an excise tax on privileges granted by government. So I quit filing and paying income tax, and it was not long before they came down on me with a heavy hand. They issued a notice of deficiency which had such a fantastic sum on it that the biggest temptation was to go in with their letter and say, "Where in the world did you get these figures?" They claimed I owed them some $60,000, but even if I had been paying taxes, I never in the world had that much money. So how could I have owed that much to them? Never argue the amount of deficiency. Fortunately, I had been given just a little bit of information. Never argue the facts in a tax case. Maximum arguments are for fools. If you are not required to file, what do you care whether they say you owe $60,000 if they are not required to file? If you are not required to file, the amount doesn't matter. Don't argue the amount. That is an issue of fact. In most instances, when you get a notice of deficiency, it is usually for some fantastic amount. The minute you say, "I don't owe that much," you have voluntarily agreed that you owe them something, and you have just given them jurisdiction. Just don't be shocked at the amount on the notice of deficiency, even if it's $10 million. If the law says you are not required to file or pay taxes, the amount doesn't matter. By arguing the amount, they will just say that you must go to tax court and decide what the amount is to be. By the time you get to the tax court, the law issues are already decided. You are only there to decide how much you owe. They will not listen to arguments of law. So I went to see the agent and told him that I wasn't required to file. He said, "You are required to file, Mr. Freeman." But I had all these Supreme Court cases, and I started reading them to him. He said, "I don't know anything about the law, Mr. Freeman, but the code says that you are required to file, and you are going to pay that amount, or you are going to go to tax court." I thought that someone there ought to know something about the law, so I asked to talk to his supervisor. I went to him and got out my Supreme Court cases, and he wouldn't listen to them. "I don't know anything about law, Mr. Freeman." Finally, I got to the problem resolution officer, and he said the same thing. He said that the only person above him was the district director. So I went to see him. By the time I got to his office, they had phoned ahead, and his security said he was out. But I heard someone in the office, and I knew he was there. I went down the elevator around the corner to the federal building and into the Senator Simpson's office. There was a girl sitting there at the desk, and she asked me if she could help me. I told her my problem. I said that I really think the district director is up there. I asked her to call the IRS and tell them that it was Senator Simpson's office calling and to ask if the district director is in. I said, if you get him on the phone, tell him that you are from the senator's office and you have a person whom you are sending over to speak to him. If he is, can he wait just 5 minutes? It worked. He was there, so I ran back up to his office. His secretary met me when I came in and said, Mr. Freeman, you're so lucky. The director just arrived. The director was very nice and offered me a coffee and a cookies, and we sat and talked. So he asked me what I wanted to talk to him about. If you have never have someone say to you, I'm from the government and I'm here to help you, watch out. But we can turn that around and approach them in the same way. So I said, I thought you ought to know that there are agents working for you who are writing letters over your name that you wouldn't agree with. Do you read all of the mail that goes out of this office over your signature? The director said, oh, I couldn't read everything. It goes out here by the bagful. That was what I thought. I said, there are some of your agents writing letters which contradicts the decisions of the Supreme Court of the United States, and they are not doing it over their name, they are doing it over your name. He was very interested to hear about it and asked if I had any examples. I just happened to have some with me, so I got them out and presented them to him. Supreme Court case supporting Freeman's position. The director thought it was very interesting and asked if I could leave the information for him, which I did. He said he would look it over and contact me within 3 days. 3 days later, he called me up and said, I am sure, Mr. Freeman, that you will be glad to know that your notice of deficiency has been withdrawn. We have determined that you are not a person required to file. Your file is closed and you will hear no more from us. I haven't heard another word from them since that was in 1980s. I hadn't paid taxes and filed taxes since 1969. The Supreme Court on trial, I thought sure I had the answer, but when a friend got charged with willful failure to file an income tax, he asked me to help him. I told him that they would have to prove that he willfully failed to file, and I suggested that he should put me on the witness stand. He should ask me if I spoke at a certain time and place in Scotts Bluff, and did I see him in the audience. He should then ask me what I spoke about that day. When I got on the stand, I brought out all the Supreme Court cases I had used with the district director. I thought I would be lucky to get a sentence or two out before the judge cut me off, but I was reading whole paragraphs and the judge didn't stop me. I read one and then another and so on. And finally, I had read just about as much as I thought I should. The judge called a recess of the court. I told Bob I thought we had it made. There was just no way that they could rule against him after all that testimony, so we relaxed. The prosecution presented its case, and he, Bob, decided to rest his case on my testimony, which showed that he was not required to file and that the Supreme Court had upheld this position. The prosecutor then presented his closing statement, and we were just sure that we had won. But at that very end, the judge spoke to the jury and told them, "You will decide the facts of this case, and I will give you the law. The law requires this man to file an income tax form. You decide whether or not he filed it." What a shock. The jury convicted him. Later, some of the members of the jury said, "What could we do?" The man had admitted that he had not filed the form, so we had to convict him. As soon as the trial was over, I went around to the judge's office, and he was just coming in through his back door. I said, "Judge, by what authority do you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read that case law. Now, how do you, a district court judge, have the authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned, and I don't care how old they are. You have no right to overturn a standing decision of the United States Supreme Court in a district court. Public law versus public policy. He said, "Name any decision of the Supreme Court after 1938 and I'll honor it. But all the decisions you read were prior to 1938, he went on. Prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S. was being tried for is a public policy statute, not public law, and those Supreme Court cases do not apply to public policy." I asked him what happened in 1938. He said that he had already told me too much. He wasn't going to tell me anymore. 1938, the Erie Railroad. While I began to investigate, I found in 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year the court claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of the boxcar as he walked along beside the tracks. The district court had decided on commercial law, negotiable instruments law, that this man was not under any contract with the Erie Railroad and therefore he lacked standing to sue the company. Under common law, natural law, he was damaged and he would have had the right to sue. This overturned a standing decision of over 100 years. Swift versus Tyson in 1840 was a similar case. And this decision of the Supreme Court then was that in a case of this type, the court would judge by the common law, natural law of the state where the incident occurred. In this Pennsylvania, in the Erie Railroad case, the Supreme Court now ruled that all federal cases will be judged under the negotiable instruments law. There would be no more decisions based on the common law at the federal level. So here we find the blending of the law with the equity. This was a puzzle to me. As I put these new pieces together, I reasoned that all courts since 1938 were merchant law courts and not common law courts. There were still pieces missing from the puzzle. A friend in the court. Fortunately, I made a friend of a judge. Now, you won't make friends with a judge if you go into a court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into a court as a wolf, if you make demands and tell the judge what the law is, how he had better uphold the law or else, remember the verse, "I send you forth as sheep in the midst of the wolves. Be ye therefore wise as serpents and harmless as doves." We have to go into a court and be wise and harmless and not make demands. We must be humble and play a little dumb and ask a lot of questions. Well, I asked a lot of questions and boxed the judge into a corner where they had to give me a victory or admit that they didn't want what they didn't want to admit. I won the next case, and on the way out, I had to stop by the clerk's office to get some papers. One of the judges stopped and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I am not sitting on a case, we will visit." America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than public law. He said in 1938, all the higher judges, the top attorneys, and the U.S. attorneys were called into a secret meeting. And this is what we were told. America is bankrupt nation. It is owned completely by its creditors. The creditors own Congress. They own the executive. They own the judiciary. And they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating under admiralty jurisdiction. Call it anything you want, but don't call it admiralty. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, no court has jurisdiction unless there is a valid international contract in dispute. When you know it is admiralty jurisdiction and they have admitted on the record that you are an admiralty court, you can demand that the international maritime contract to which you are supposedly a party to and which supposedly have been breached be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb. Well, I never knew that I got involved with an international maritime contract, so I deny that such contract exists. If this court is taking jurisdiction in admiralty, then place the contract into evidence so that I might challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are the bankers' slaves. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. This is the key behind the buildup of the United Nations as a military force. This is the key to disarming Americans. This is the key to ending the Cold War. Like now, we have no more enemy, so we can melt all our guns. Wrong. The bankers plan to foreclose. They just don't want their heads blown off while they're doing it. So they dictate to the Congress to get rid of the guns, etc. The reason they don't want to tell everyone that they own everything is that there are still too many privately owned guns in America today. There are uncooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all courts into a world court, it is not expedient to admit the jurisdiction of the courts they are operating under. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. Jurisdiction. The Constitution of the United States mentions 3 areas of jurisdiction in which the courts may operate. Common law. Common law, natural, and constitutional law is based on our Creator's laws as originally presented by Moses. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please, as long as you do not infringe on the life, liberty, or property of another. You have the right to make a fool of yourself, provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action which prevents a man from making a fool of himself. For instance, when you cross state lines, you will probably see a sign which says, "Buckle your seatbelts. It's the law." This cannot be common law because who would be injured if you did not buckle up? Nobody. This would be compelled performance, but common law cannot compel performance. Any violation of common law is a criminal act that is punishable. Equity law. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So, if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court. This is a criminal action. Are seatbelt laws equity laws? No, they are not, because you cannot be penalized or punished under equity jurisdiction for not keeping to the letter of the contract. This has, of course, changed since the publishing of this article, so read on. Admiralty or maritime law. Admiralty is a civil jurisdiction of compelled performance, which has criminal penalties for not adhering to the letters of the contract, but this only applies to international contracts. Now we can see what jurisdiction the seatbelt law and all traffic laws, building codes, ordinances, tax codes, so on, etc. are under. Whenever there is a penalty for failure to perform, such as a willful failure to file, that is Admiralty maritime law, and there must be a valid international contract in force. However, the courts don't have to admit that they are operating under maritime admiralty jurisdiction, hereafter noted as AM. So they took the international law of the law of merchants and adopted it into our codes. This is what the Supreme Court decided in the Erie Railroad case, that the decision would be based on a commercial law or business law, and that there will be criminal penalties associated with it. Since judges were instructed not to call it Admiralty Maritime Jurisdiction, they call it Statutory Jurisdiction. I looked for statutory jurisdiction in 4th edition of Black's Law Dictionary. It's not there. So I looked up statutory. Under its definition is this paragraph. This word is used to designate the written law in contradistinction to the unwritten law. Foster versus Brown, 199 GA period 444, 334 S period E period 2D, 530, 535, see common law. Unwritten law is common law. Contradistinction means as opposed to or opposite to. Court of contract. You may ask how we got into this situation where we can be charged with failure to wear a seatbelt and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, but you must understand that in Article 1, Section 10, the Constitution gives us the unlimited right to contract as long as we do not infringe on the life, liberty, and property of someone else. Contracts are enforceable, and the Constitution gives two jurisdictions where contracts can be enforced, equity or admiralty, but we find them being enforced in statutory jurisdiction. This is an embarrassing part of the courts that we can use to box the judges into a corner in their own courts. We will cover this more later. Contracts must be voluntary. Under the common law, both parties must enter into every contract knowingly, voluntarily, and intentionally, or the contract is unenforceable and void. These are characteristics of a common law contract. There is another characteristic. The contract must be based on substance. For example, contracts used to read for $1 and other valuable consideration. I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now suppose you wrote a contract that said for one Federal Reserve note, or FRN, and other consideration, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go into common law court and get justice or remedy? No, you could not. No substance, no contract, because you see, a Federal Reserve note is a colorable dollar as it has no substance and in a common law jurisdiction, that contract would be unenforceable. Colorable, that which is in appearance only and not what it purports to be. Hence, counterfeit, foreign, forged, having the appearance of truth. Black's Law Dictionary, 5th edition. Colorable money in colorable courts. The word colorable means something that appears to be genuine but is not. Maybe it looks like $1 and maybe it spends like $1, but it is not redeemable for lawful silver or gold money. It is colorable, fiat, fake, false. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract, and colorable contracts can be enforced under a colorable jurisdiction. So by creating Federal Reserve notes, the government had to create a colorable jurisdiction to cover the kinds of contracts that use them. We now have what is called statutory jurisdiction, which is not genuine admiralty jurisdiction. Judges are enforcing a colorable admiralty jurisdiction because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. So let's see how we got under this statutory jurisdiction. Uniform Commercial Code. The government established a colorable law system to fit their colorable currency. It used to be called the law of merchants, or the law of redeemable instruments, because it dealt with paper, which was redeemable in something of substance. But once Federal Reserve notes had been declared unredeemable, there had to be a system of law which was completely colorable from start to finish. This system of law is codified as the Uniform Commercial Code, UCC, and has been adopted in every state of the Union. This is colorable law, used in all of the courts of the nation. I explained one of the keys earlier, which is the country is bankrupt and we have no rights. If the master says jump, the slave better jump, because the master has the right to cut off his head. As slaves, we have no rights, but the creditor master had to cover up that fact. So they created the system of law called the UCC. This colorable jurisdiction under the UCC is the next key to understanding what has happened. Contract or agreement. One difference between common law and the UCC is that in the common law, contracts must be entered into knowingly, voluntarily, and intentionally. Under the UCC, this is not so. First of all, contracts are necessary, but under the UCC, agreements can be binding. And if you only exercise the benefit of an agreement, it is presumed or implied that you intended to meet the obligation associated with those benefits. If you accept the benefit offered by the government, you are obligated to follow every statute involved with the benefit. So, their method is to get everybody exercising a benefit, and they don't even have to tell the people what the benefit is. Some people think it is the driver's license, the marriage license, or the birth certificate, etc. I believe it is none of these. The compelled benefit. I believe the benefit being used in that we have been given the privilege of discharging debt with limited liability instead of paying the debt with substance. When we pay a debt, we give substance for substance, equal value for equal value. If I buy a quart of milk with a silver dollar, that dollar paid for the milk, and the milk paid for the dollar, substance for substance, pound for pound. But if I use Federal Reserve to buy the milk, I have not paid for it. There is no substance in the Federal Reserve note. It is worthless paper given in exchange for something of substance and value. Congress offers us a remedy in the form of a benefit. Debt money, fake money, authorized by the federal United States, can be spent all over the continental United States. It is declared legal tender for all debts, public and private, and the limited liability is that you cannot be sued for not paying your debts when you discharge the charge using the colorable money. So they have said, we are going to help you out. You can discharge your debts instead of paying your debts. When we use this colorable money to discharge our debts, we cannot use common law courts. We can only use colorable law courts. We are under the jurisdiction of the UCC. We are using non-redeemable negotiable instruments, and we are discharging debts rather than paying debts. Redeem and recourse. Every system of civilized law must have two characteristics: remedy and recourse. Remedy is a way to get out from under the law. Recourse is if you have been damaged under the law. You can recover your loss. The common law, the law of merchants, and even the UCC all have remedy and recourse, but for a long time we could not find it. If you go to the law library and ask to see the UCC, they will show you a shelf of books completely filled with the UCC. When you pick up one of the volumes and start to read it, it will seem it has been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse are found in the UCC. They are found right in the first volume at UCC 1-207 and UCC 1-103. Remedy. The making of valid reservation of rights preserves what whatever rights the person possessed at the time and prevents the loss of such rights by application of the concept of a waiver or estoppel, UCC 1-207.7. It is important to remember when we go into a court that we are in a commercial international jurisdiction. If we go into court and say, I demand my constitutional rights, the judge will most likely say, you mentioned the Constitution again and I'll find you in contempt of court. We don't then understand how he can do that. Hasn't he sworn to uphold the Constitution? The rule here is this. You cannot be charged under the jurisdiction and defend under another. For example, if the French government came to you and asked if you filed your French income tax for a certain year, do you go to the French government and say, I demand my constitutional rights? No. The proper answer is, the law doesn't apply to me. I'm not a Frenchman. You must make your reservations of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So in the UCC court, you must claim your reservation of rights under UCC 1-207, now changed to UCC 1-308. Section 21, UCC 1-308 goes on to say, when a waiverable right or claim is involved, the failure to make a reservation, therefore, causes a loss of the right and bars its assertion at a later date, UCC 1-308.9. You have to make your claim known early. Further, it says, the sufficiency of a reservation, any expression indicating an intention to reserve rights, is sufficient, such as, without prejudice, UCC 1-308.4. Whenever you sign any legal paper that deals with the Federal Reserve notes in any way, under your signature right without prejudice, or without prejudice UCC 1-308. This reserves your rights. You can see at 1-308.4 that you have sufficiently reserved your rights. It is very important to understand just what that means. For example, one man who used this in regards to a traffic ticket was asked by a judge just what he meant by writing without prejudice on his statement to the court. He had not tried to understand the concept involved. He only wanted to use it to get out of paying his ticket. He did not know what it meant. When the judge asked him what he meant by signing it that way, he told the judge that he was not prejudiced against anyone. The judge knew that the man had no idea of what it meant, so he lost the case. You must know what it means. Section 22, without prejudice, UCC 1-308. When you use without prejudice or without prejudice UCC 1-308 in connection with your signature, you are saying, I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally. I do not accept the liability of any compelled benefit or any unrevealed contract or commercial agreement. What is the compelled performance of an unrevealed commercial agreement? When you use Federal Reserve notes instead of silver dollars, it is voluntary. No. Is it voluntary? No. The answer to that is no. There is no lawful money, so you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts. How nice they are. But if you have not reserved your rights under UCC 1-308, you are compelled to accept the benefit and are therefore obligated to obey every statute, ordinance, and regulation of the government at all levels of the government, federal, local, and state. If you understand this, you will be able to explain it to the judge when he asks, and he will ask. So be prepared to explain this statement to the court. You will also need to understand UCC 1-103, argument and recourse. If you want to understand this fully, go to the law library and photocopy these two sections from the UCC. It is important to get the Anderson's version. Some of the law libraries will only have the West Publishing version, which is very difficult to understand. In Anderson's, it is broken down with decimal decimals into 10 parts, and most importantly, it is written in plain English. Section 23, Recourse. Recourse appears in UCC at 1-103.6, which says the code is complementary to the common law, which remains in force except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. UCC 1-103.6. This is the argument to use in a court. The code recognizes the common law. If it does not recognize the common law, the government would have to admit that the United States is bankrupt and completely owned by its creditors. But it is not expedient to admit this. The code was not written to entirely override the common law. Therefore, if you have made sufficient, timely, and explicit reservation of your rights pursuant to UCC 1-308, you have insisted that the statutes be construed in harmony with the common law. If the charge is a traffic ticket, you may demand that the court produce the injured person who has filed a verified complaint. For example, if you were charged with failure to buckle your seatbelt, you may ask the court who was the injured party as a result of your failure to buckle up. However, if the judge won't listen to you and just moves ahead with the case, you will want to read to him the last sentence of UCC 1-103.6, which states that the code cannot be read to preclude a common law action. Tell the judge, Your Honor, I can sue you under the common law for violating my rights under the UCC. I have a remedy under the UCC to reserve my rights under the common law. I have exercised my remedy, so you must construe this statute in harmony with the common law. To be in harmony with the common law, you must bring forth the damaged party. Note, actually, it is better to use a rubber stamp because this demonstrates that you had previously reserved your rights. The simple fact that it takes several days or a week to order and get a stamp shows that you had reserved your rights prior to signing the document. Anderson's Uniform Commercial Code Lawyers Cooperative Publishing Co. Basically, he's saying it's showing intent. If the judge insists on proceeding with the case, act confused and ask the question, let me see if I understand you. Your Honor, has this court made a legal determination that the sections of the UCC 1-308 and 1-103 of the UCC, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he says yes, then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so you have boxed him into a corner. Section 24, practical application in traffic court. Just so we can understand how this whole process works, let's look at a court situation such as a traffic violation. Assume you ran through a yellow light and the policeman gave you a ticket. The first thing you want to do is delay the action at least 3 weeks. This you can do by being pleasant and cooperative with the policy enforcer. Explain to him that you are very busy and ask if he would please set your court appearance for about 3 weeks away. At this point, we need to remember that the government's tricks. I am from the government. I am here to help you. So we want to use this approach with them. The next step is to go to the clerk of the traffic court and say, I believe it would be helpful if I talk to you because I want to save the government some money. This will get his attention. I am going to appeal this case, as you know, in an appeal. I have to have a transcript, but the traffic court doesn't have a court reporter. If it would be a waste of taxpayers' money to run me through this court and then have to give me a trial, de novo, new trial, in a court of record. I need a transcript for appealing, and to save the government some money, maybe you could schedule me to appear in a court of record. You can show the date on the ticket, and the clerk will usually agree that there is plenty of time to schedule your trial for a court of record. Now your first appearance is in the court of record and not in the traffic court, where there is no record. When you get into the court, there will be a court reporter there who records every word the judge speaks. So the judge is much more careful in a court of record. You will be in a much better situation there than in traffic court. If there is no record, the judge can say whatever he wants. He can call you all sorts of names and tell you that you have no rights and so on, and deny it later. When you get into court, the judge will read the charges, driving through a yellow light or whatever, and this is the violation of Ordinance XYZ. He will then ask, do you understand the charges against you? Well, Your Honor, there is a question I would like to ask before I make a plea of innocent or guilty. I think it could be answered if I could put the officer on the stand for a moment and ask him a few short questions. Judge, I don't see why not. Let's swear in the officer and have him take the stand. 5. Is this the instrument that you gave me, handing him the traffic citation? The officer. Yes, this is a copy of it. The judge has the other part of it. Where did you get my address that you wrote on the citation? Well, I got it from the driver's license. Number 4 above is very important to get into the record, clearly stating that you do not understand the charges. With that in the record, the court cannot move forward to judge the facts. This will be covered later on. Handing the officer your driver's license is this the document you copied my name and address from? Yes, this is where I got it. While you have got that in your hand, would you read the signature that's on the license? The officer reads the signature. While you are there, would you read into the record what it says under the signature? The officer says, it says, without prejudice, UCC 1-308. The judge says, let me see that license. He looks and turns to the officer. You didn't notice this printing under the signature on this license when you copied his name and address onto the ticket? Officer, oh no, I was just getting the address. I didn't look down there. Judge, you're not very observant as an officer. Therefore, I'm afraid I cannot accept your testimony in regards to the facts of this case. This case is dismissed. In this case, the judge found it a convenient way out. He could say that the officer was not observant enough to be a reliable witness. He did not want to admit the real nature of the jurisdiction of his court. Once it was in the record that you had written without prejudice UCC 1-308 on your license, the judge knew that he would have to admit, A, that you had reserved your common law rights under the UCC, and B, that you had done it sufficiently by writing without prejudice UCC 1-308 on your driver's license. C, that the statutes would not have to be read in harmony with the common law, and the common law says that the statutes exist, but there is no injured party. And D, that since there is no injured party or complaining witness, the court has no jurisdiction under the common law. If the judge tries to move ahead anyway and try the facts of the case, you will want to ask him the following questions. Your Honor, let me understand this correctly. Has this court made a legal determination that it has authority under the jurisdiction that it is operating under? To ignore 2 sections of the Uniform Commercial Code, which have been called to its attention. If he says yes, tell him that you put the court on notice that you will appeal his legal determination, and that if you are damaged by his action, you will sue him in the common law action under the jurisdiction of the UCC. This will work just as well as with the International Revenue Service. In fact, we can use the UCC with the IRS before we even get to the courts. Section 25. Using the code with the IRS. If the IRS sends you a notice of deficiency, this is called a presentment. In the UCC, a presentment in the UCC is very similar to the common law. First, we must understand just how this works in the common law. Suppose I get a man's name from the phone book, someone I have never met, and I send him a bill. or an invoice on a nice letterhead which says, "For services rendered, $10,000. And I send this to him by certified mail, return receipt requested, at the address taken from the phone book. The man has got to sign for it before he can open it, so I get green card receipt that he received it. When he opens it, he finds an invoice for $10,000 and the following statement: if you have any questions concerning this bill or the services rendered, you have 30 days to make your questions or objections known." Of course, he has never heard of me, so he just throws the bill away and assumes that I am confused or crazy. At the end of 30 days, I go to the court and I get a default judgment against him. Received a bill for $10,000 and was given 30 days to respond. He failed to object to it or ask any questions about it. Now he has defaulted on the bill, and I am lawfully collect the $10,000. This is common law. The UCC works on the same principles. The minute you get a notice of deficiency from the IRS, return immediately with the letters that say, "The presentment above is dishonored. Your name has reserved all of his rights under the Uniform Commercial Code at UCC 1-308. This should be all of that is necessary, as there is nothing more that they can do. In fact, I recently helped someone in Maine who received a notice of deficiency. The man sent a letter such as this, dishonoring the presentment. The IRS wrote back saying that they could not make a determination at the office, but were turning it over to collections department. A letter was attached from the collections department which said that they were sorry for the inconvenience they had caused him and that the NOD had been withdrawn. Notice of deficiency had been withdrawn. So you can see that if it is handled properly, these things are easily resolved. Impending bankruptcy, Section 26. On my way here, I had a chance to visit the governor of whatever state. He is very concerned that if he runs for office this November, that there won't be a state at the end of 4 years. He believes that the international bankers might foreclose on the nation and officially admit that they own the whole world. They would round up everybody in the state capitol buildings, put them in an international internment camp, and hold them indefinitely. They may give them a trial, or they may not. They may do whatever they want. As I explained earlier, it has not been expedient to foreclose on a nation until they could get everything ready. This is where the Federal Emergency Management Agency comes in. It has been put in place without anyone really noticing it. FEMA, or the Federal Emergency Management Agency, has been designed for when America is officially declared bankrupt, which would be a national emergency. In a national emergency, all constitutional rights and all law that previously existed would be suspended. FEMA has created large concentration camps where they would put anyone who might cause trouble for the orderly plan and process of the new regime to take over the nation. Even a governor would be thrown into one of these internment camps and kept there indefinitely. This is all in place now, and they just wait to declare they're just waiting to declare a national emergency. Then even the state governments could be dissolved. Anybody who might oppose the new regime would be imprisoned until a new set of laws could be written and a new government set up. The government knows all this, and the governor knows all of this, and he is very concerned. He doesn't want to be in office when all this happens. I, Honorable Freeman, visited with him, and I told him that there are certain actions we should take right now. I think that we should consider the fact that, according to the UCC, each state is and accommodation party to the national debt. To understand this, we must realize that there are two separate entities known as the United States. And in all actuality, there's like 4 or 5 different United States. There's 12 different variations of definitions. Again, this book was written in like 1990. So with my studies conclusively showing there are like 12 or 13 different definitions for the United States, and there are, in fact, 4 different United States that are recognized as entities. So keep that in mind, ladies and gentlemen. This literature is from 1990, and things have evolved, things have progressed, and even the author of this says that constantly he is upgrading his work. So with that, I'm going to close out this. This book is called The UCC Connection: How to Free Yourself from Legal Tyranny. Happy is the man that findeth wisdom, and the man that getteth understanding. Proverbs 3:13. And I would advise, I'm going to show everybody a cover of it. We're on page 26 of this book, and I'd advise everybody to go get yourself a copy of it and really check it out. Become learned, share with your friends and family. But an important part that this guy makes in the revelations of his discoveries is these internment camps, these FEMA camps, these things that have been set up years and years ago. And something that's interesting to note, and everybody should be very keen and wise upon, is the fuse that was lit in Virginia not more than a few weeks ago, where a governor came out and said that he was wanting to take some guns. This is the prime conditions for utilizing these places called FEMA camps. And I want you guys to stay alert, be awake, have plenty of food rations, because this movement of militias is spreading like Zika virus or like West Nile. In 24 hours, it went from one coast to the other. And God bless every man, woman, and child standing up for their unalienable rights and arming themselves and protecting themselves and standing with their local sheriffs that are abiding by the Constitution. And so be safe out there. Get to know your neighbor, because unfortunately, I think at this point in time, the government has crossed a line that they will never be able to return from. And it's only a matter of time now before things escalate to such a degree that won't be recoverable. I think they've already done that. I think they've already reached the point of no return. I think they already drew a line in the sand and crossed it and can't get back. There's no way the American people could trust the people that they have voted for to protect their rights when they know the true history of the nation. And in fact, we've all been doomed from birth and deemed as slaves to the bankers, who are actually insolvent and don't have anything of value. They usurp power, otherwise not delegated to them, by the manipulation of minds and currency through the twisting of languages and using lawyers to usurp power that otherwise they would not have. So I appreciate you guys for joining me. Thank you for all your support. Again, this is the book I was reading from. And so if you get a chance, I think you can pick it up for like $8 or $9. It's also free online, I think. I like having paperback copies because, you know, if the power ever goes out, I'm going to want some good literature to read. So thank you guys for joining me. I really appreciate it. Still looking forward to hearing back from Ken Doss. He's still doing some research. And I think we might do a video on name decrees, how to execute a name decree. If you're interested in something like that, private message me. I have a brilliant man who's executed a name decree, and since then, he hasn't been bothered by any law enforcement. He hasn't had any more court dates. Everything just kind of disappeared. All his debts, everything, because he occupies the executor office and he has a name decree to prove it. He owns you. And when I say you, I mean he owns his all caps nom de guerre. He owns it. And he has an authenticated birth certificate with a name decree. And he wants to walk people through that. And so if you're interested in that, private message me. We'll set it up. Of course, it comes at a fee. The man's time is valuable. And a man is worth his daily labor and wages. So with that said, thank you for joining me. God bless you guys. Have a Merry Christmas. Keep alert. stay vigilant, stay awake, pay attention to what's going on, because there's been a fuse lit to a powder keg that can't be put out. And when we look at our brothers and sisters in Virginia, understand this: they're tired of being oppressed, just like the rest of us. But they have an attitude down there that many peril in comparison, because of the way their government is moving against them. So stay alert and talk to your local sheriffs, because in times of controversy, you really, really need to have a good sheriff to stand behind, or to stand in front of you to make sure that this gross, egregious encroachment on liberties and rights and freedoms does not happen in your community. So, thanks again for joining. Have a great day.